So the offer and legal process with development finance is much more intense, as we mentioned previously, than bridging finance and buy-to-let, for example. So the legal process can be longer, more intense, more questions, more things to answer and show. And we mentioned earlier about CPSE, which is the Commercial Property Standard Inquiries. These are an absolute must when it comes to development finance. So you will tend to find that these will always be required to be answered, and they can be quite intrusive. There's a lot of questions that need answering, and it tends to be that the vendors of sites can be quite slow in answering these as well. So it does tend to drag the legal procedure on somewhat. So when it comes to the offer, we'll start off with that bit. The offer will come over to you. It will detail everything, hopefully, it's the same as the agreement in principle when you were first kind of issued terms. Hopefully it'll be the same. But that offer is the bit that you really need to read in detail so that you can understand how much you're getting net day one, so you can understand how much you're getting for your build costs, understand when the tranches are going to be drawn down, the cost involved with each tranche, the cost involved if you don't draw down any of the tranches, because normally as a rule of thumb, development finance, you only pay interest on what you've drawn down. There's no non-utilisation fees or anything like that. But that offer is the bit that you need to read to ensure that there aren't any of those fees. Once you're happy with the offer, that's when it then goes into legals, that's when the inquiries start flowing, and that's where you start to get involved in doing your searches, for example, answering the inquiries, managing the vendor's expectations and getting them to reply as quickly as possible, and starting to go through, obviously, signing the personal guarantees, your debentures, the collateral warranties. The collateral warranties we will go through in a bit more detail later, but they're essentially step-in rights that your contractor and architect may sign, which means that if you can't fulfil the development for whatever reason, that they can step in and carry it on alongside the lender or a future purchaser. So once all of that's done, once you've had your independent legal advice, that's when the legal process sort of comes to its end point, and obviously there's going to be no end of further inquiries, and there'll be things around the contractor, no doubt, and maybe things off of the results of the searches and whatnot. But hopefully the legal process won't take too long as you can manage the vendor's speed, and obviously we would assist in managing the lender's speed. But hopefully the legal process shouldn't take too long. But you will find it much more intense than if you're going for a standard bridging loan. Hence, the cost of that legal process is significantly more than other finance products. You will also be expected, similarly as you would be on bridging finance or a buy-to-let, for example, you will be expected to pay for the lender's legal cost as well. If you've got any private investors, which you may have, then there may be deeds of subordination, which is essentially if your investor is coming in on a second charge and your development lender is coming in on a first charge, a deed of subordination is a deed signed between the two of those to ensure that they both are respectful of their position within the charge holding order. And it just means that the second charge holder can't do anything to affect the first charge holder. So there'll need to be some documents signed between those as well. And obviously if you've got an investor as well, they'll need to take independent legal advice, etc. to come into it as well. So that can add some time onto that legal process as well. But all in all, that's the offer process and the legal process.